I understand the severity of these allegations, but I stand by my testimony. We followed every protocol necessary to ensure safety.
The courtroom that morning felt ordinary, almost boring, the kind of setting where nothing dramatic seems likely to happen. People were seated quietly, papers shuffled softly, and the judge took his place on the bench with the calm confidence of someone who has seen every possible excuse, attitude, and mistake imaginable. This was not a trial, not a verdict day, and not a moment anyone expected to remember. It was simply a status conference in the case of the state of Michigan versus Chloe White, a hearing that existed only to check progress and ensure the process was moving forward correctly. At the previous hearing, the court had granted the defendant extra time to obtain legal counsel. That decision was not automatic kindness. It was procedural fairness. The court had done its part, and now it was time for the defendant to show that she had done hers. The judge was not interested in emotion or explanations. He wanted a clear answer to a straightforward question. Had the defendant hired an attorney, yes or no? The defense spoke first, explaining that the defendant had reported she obtained counsel and intended to have that attorney present at the next hearing. Based on that representation, the defense requested another adjournment. On its face, the request was reasonable. Courts grant adjournments every day, especially when legal representation is involved. But reasonableness in court is not just about what is asked. It is also about how people conduct themselves while asking. The judge turned his attention to the defendant and asked her directly whether she had retained other counsel. It was a simple moment, one that could have passed in seconds. A single word would have been enough. Instead, the defendant began talking. She explained that the lawyer was hired at the very last minute, emphasized that the lawyer was doing her a favor, and went into details about how the attorney was not charging her what he normally charged. She mentioned names and relationships that were irrelevant to the court's decision. As she continued, it became clear that she did not understand the environment she was in. Courtrooms operate on precision, not narrative. Judges do not need background stories unless they ask for them. The judge interrupted her firmly and told her he did not need to know all of that. The interruption was not rude. It was corrective. It was the judge drawing a boundary and reminding her that this was not a conversation between equals, but a structured legal proceeding. The judge then decided to adjourn the case for 2 more weeks and set a specific date and time for the next hearing. That decision alone reflected patience. The court could have pushed the matter forward or expressed frustration, but instead, it gave the defendant the benefit of time once again. However, the judge did not move on immediately. He paused, and that pause signaled that something more important needed to be addressed. The judge reminded the defendant of her last appearance in court. He spoke about her attitude and demeanor, choosing his words carefully but honestly. He recalled that she laughed during the proceedings, behaved casually, and at one point even left the podium without permission. Those actions might seem small to someone unfamiliar with courtroom culture, but to a judge, they represent disrespect for the process and a failure to understand the seriousness of the situation. At that earlier hearing, the judge had chosen restraint. He had allowed her to leave without punishment, believing that perhaps stress or confusion had influenced her behavior. He believed that once she left the courtroom, she would reflect and correct herself. Judges often make that choice because the goal of the court is compliance, not conflict. But that expectation was now in question. The judge explained that after that hearing, he became aware of emails the defendant had sent to the Department of Community Corrections. These were not required updates, not formal requests, and not appropriate communications. They were being interpreted as harassing and unnecessary. This detail changed everything. Court supervision operates on strict rules, and unauthorized contact is not a minor issue. It signals defiance, misunderstanding, or an attempt to manipulate the system. The judge made it absolutely clear that there was no reason for the defendant to be emailing community corrections. The rule was simple and non-negotiable. If they call her, she may speak to them. Otherwise, there should be no communication. The judge emphasized that this was not a suggestion, it was a condition. Courts rely on structure, and when someone ignores that structure, consequences follow quickly. The judge then addressed the seriousness of the situation directly. He told her that her behavior at the last hearing had almost resulted in her being taken into custody. That statement carried weight. Judges do not use language like that casually. It was a reminder that the court had already stood at the edge of revoking her freedom and chose not to step over that line. He explained that he had passed on taking action because he believed she understood how she was supposed to behave going forward. He believed that they were on the same page about respect, communication, and compliance. Seeing the emails now made him question that belief. The tone of the courtroom shifted. What had started as a procedural update had become a warning. The judge told her plainly that if he received anything like this again, he would likely revoke her bond. That was not a threat meant to scare her. It was a statement of fact. Bond revocation does not require emotion or debate. It happens when conditions are violated, and judges have broad authority to enforce those conditions. Jail would not be a possibility. It would be a consequence. The judge asked her if she heard and understood him. The defendant responded quietly and respectfully this time, saying yes. There was no argument, no explanation, and no pushback. The judge concluded by saying he did not want to see her in court again for issues related to behavior or improper communication. The case was continued, and the courtroom moved forward, but the message lingered. The court's patience had been extended, but it was not unlimited. What happened next proved that the courtroom was not finished delivering lessons that day. As the next case was called, a new defendant stepped forward, and almost immediately, the atmosphere shifted again. This time, the issue was not attitude outside the courtroom, but control inside it. The defendant, Thomas Ryan Belcher, stood beside his assistant public defender as the judge confirmed his name for the record. Everything appeared routine until the defendant made an unexpected request. He wanted to fire his lawyer. That request instantly changed the direction of the hearing. Judges hear complaints about attorneys often, but they also know that frustration does not equal legal justification. The judge asked the defendant why he wanted to remove his public defender. The defendant claimed he was not receiving proper representation. He said the lawyer wanted to adjourn the case, even though he did not want that. He complained that the lawyer had not come to see him enough and had not properly discussed the case with him. The judge listened without interrupting, allowing the defendant to fully explain his position. Once the defendant finished, the judge began asking focused questions. It quickly became clear that the defendant had, in fact, spoken with his attorney multiple times. The issue was not absence, but disagreement. The judge explained that public defenders are not personal assistants. They are legal professionals tasked with protecting the defendant's rights, even when that protection is unpopular. The judge explained that discovery was still incomplete, and that proceeding to a preliminary examination without reviewing all evidence will be reckless. He asked the defendant directly whether he wanted to move forward without knowing the full scope of the case against him. When the defendant admitted that he wanted to see the discovery first, the judge explained that an adjournment was the only way that could happen. At this point, the judge expressed frustration, noting that the defendant seemed willing to accept the judge's explanation, but not the same explanation from his own lawyer. The judge reminded him that legal training matters. Without a law degree, it would be unwise to override professional judgment based on impatience or suspicion. The court exists to ensure fairness, not speed. The judge denied the motion to fire counsel. The public defender then formally requested a 2-week adjournment, explaining that investigation was still ongoing. The judge granted the request and set a new date. During the same hearing, the issue of competency was addressed. A report had been completed, reviewed by both sides, and shared with the defendant. Both parties stipulated to its findings. The judge made an official ruling that the defendant was competent to stand trial. meaning he understood the nature of the proceedings and could assist in his defense. This finding was not emotional or personal. It was legal and final. Bond was continued, and the case was adjourned. As the courtroom prepared to move on, the pattern of the day became clear. Whether it was improper communication, unrealistic demands, or resistance to professional guidance, the court consistently reinforced one message: process matters. Respect for structure is not optional, and attempts to control the system only delay justice. If you want to understand how real courtroom decisions are made and how small choices can lead to serious consequences, stay with this channel. These cases show that court is not about winning arguments. It is about following rules. Subscribe, follow, and keep watching for more real courtroom stories where behavior, not just evidence, decides what happens next.